Swamy to move Protection of Children from Sexual Offences Amendment Bill 2016. Please.
Thank you, Mr. Deputy Chairman. This is a matter of law arising out of the passage of the 2012 bill on what is called as the Protection of Children from Sexual Offences Act. That act was widely welcomed, but the drafting of some sections have been so poor that many people in the judiciary particularly have spoken to me about it and pointed out the harassments that they themselves are being subject to by the application of this act. So I'll begin by saying that my bill my amendment bill is essentially aimed at section 19 and is seeking the deletion of the entire section. So let me begin by saying what the section says.
No. He is moving his bill.
Don't worry, Ramesh ji, aap chinta mat kariye.
The section 19 of this act says, reporting of offences. 1. Notwithstanding anything contained in the Code of Criminal Procedure 1973, any person, I underline the word any person, including the child, who has apprehension that an offence under this act is likely to be committed or has knowledge that such offence has been committed, he or she shall provide such information to 1. the Special Juvenile Police Unit or the local police. Then it goes on for other sections. Some of them are just routine, and I don't need to read all of them, except to say that subsection 5 says where the Special Juvenile Police Unit or local police is satisfied that the child against whom an offence has been committed is in need of care and protection, then it shall, after recording the reasons in writing, make arrangements to give him such care and protection, including admitting the child into a shelter home or the nearest hospital within 24 hours of the report as may be prescribed. Now, on the face of it, you may not see any misuse of the law, but why the judiciary has been complaining, at least to me, is that when it says that any person who has the knowledge that such an offence has been committed shall provide the information to the police. Now, there are cases, there are not one or two, there are at least 27 listed cases in different parts of the country at different levels, particularly at the High Court level, where a judge is hearing a divorce case. In the divorce case, the wife or the estranged wife, she says that I want a divorce because my husband has molested my daughter. Now, this the judge hears. Now, it's not the judge's fault, or this is not the judge's happen to be an eyewitness. The judge has been assigned this brief by the Chief Justice of the High Court, for example, to hear this matter. Now, what happens is, if the judge does not now go and file a report with the police, very often the husband or the wife, as the case may be, they make a complaint that the judge, having heard this, should have gone and report to the police, and therefore section 21, which takes that as a cognizable offence, and an FIR is registered against the judge. The government should call for this report from the judiciary or from the state governments and find out how many such things are misused. This is a way of terrorizing the judge by one of the clients, either the the plaintiff or the respondent. And therefore, what happens is the judges are now increasingly refusing to take divorce cases. And this has caused a big backlog of divorce cases because most of the judges are afraid that this is what would happen. So I would begin by saying, that's why I've said in my statement of objects and reasons the following. Section 19 of the Protection of Children from Sexual Offences Act 2012 compels even court judges, because it says any person, court judges hearing divorce case or in marriage discord cases to provide information to the police authorities or otherwise face penal punishment under Section 21 of the said Act. This places an unacceptable onus on the public and public judicial persons in their mere apprehension of a possible offence being committed. This section should have had an exception. The exception should have said all those who conduct judicial proceedings or adjudication proceedings shall be exempt from this section. And so there is a big flaw in the drafting. And consequently, therefore, the whole section has to be struck down and a new amendment may be brought by the government. Now I say this because having such a vague presentation leads to misuse, and this badly drafted is capable of, I don't know how it escaped, whether this went to the Joint Select Committee. I have not been able to find from the Parliamentary Library any evidence of that. This author having such an important, I think because of the Nirbhai matter or something, they rushed through this and brought it in. But now we must understand in our country, 0 to 18, which is considered as juvenile, they constitute 35% of the population. And these cases can easily be instituted because supposing the children working in restaurants, the child labor is taking place, then there you have situations of where there are hostels and where the teachers can be implicated. Then there are issues of pedophile and so many other things are there. And these matters have to be gone through with great care. And therefore I am saying, I'm running out of time, Your Honor, I'm not...
No problem. You can...
I can't go beyond 5 o'clock, no?
No, I'll tell you. If within 5 o'clock, no, if within 5 o'clock you do not conclude, you can continue on the next day and
yes,
try to
yes, yes. So therefore, I am asking today that where there is question of where an authority has to report something, this causes great deal of problems. Now, what happens in a restaurant, in a roadside restaurant, there are children who are acting as child labor. Anyone who wants to get into the hotel or the restaurant owner into trouble because of personal animosity, he can go and say that I have witnessed this happen, where the boy who was serving was given a tight slap and kicked and brutalized. So where are the safeguards? This question of safeguards is what I am focusing my attention on. Now I am asking you, your Deputy Chairman, sir, please read section 6. The Special Juvenile Police Unit or local police shall without necessary delay, within a period of, without unnecessary delay, but within a period of 24 hours report the matter to the Child Welfare Committee and the special court. And where there is no special court, there has been designated to the Court of Sessions, including the need of the child for care and protection steps taken. Now here again, supposing there is a custody matter, because of this section 5 and section 6, the child whose custody is with the mother, say, the husband can ensure through this section that it is now sent, that person is sent to a special home and therefore taken out of the custody of the mother.
Okay, now you can continue your speech on the next day when private member's bill is taken up.
Yes.
So it's not, your speech is not concluded.
Yes.
Now I have some special mention. I will read out the name. Sri Tiruchi Shiva. Absent. Sri Oscar Fernandez. Absent. Sri T. Ratnivel. Also absent. The House stands adjourned till 11 a.m. on Monday, the 27th March 2017.